Hello, and welcome to Ipse Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Benjamin Edwards, Associate Professor of Law at the University of Nevada, Las Vegas, William S. Boyd School of Law. We will discuss his article, The Professional Prospectus, a Call for Effective Professional Disclosure, which was published in the Washington and Lee Law Review. So welcome to the program, Ben.
Thank you. Glad to be here.
Yeah, so I'm delighted to have you on the show. We've discussed and collaborated on this subject before, and as you know, I love this paper and idea, which is something of a modest proposal in the Swiftian sense.
You may have a minority opinion here.
So I'm wondering if you could start by just kind of laying out the nature of the problem that you see. I mean, the paper is really about sort of effectively market failures or principal agent problems in the provision of professional services to consumers. What's the problem?
Yeah. So the problem is essentially when you go to a professional, there's this big information asymmetry gap where you just don't know what you need, and you have to rely on the professional to tell you that. For example, I took my check engine light came on recently, and I took it to the dealership, and I don't know why the light's on. They're going to tell me why the light's on, and they're going to tell me what I need to do to fix it. And I don't have a whole lot of expertise around automotive repair. And so my ability to really doubt them or second guess them, if they tell me I have a misfiring carburetor, I have no idea if my 2013 car even has a carburetor. And so when you look at the market for professional services, if you need a lawyer, you need a doctor, you need a dentist. When you go meet with them and ask them, what can you do? How can you help me with this problem? What do I do? If the dentist tells you you have a cavity or you don't have a cavity or you need this procedure or that procedure, you may just have to take it because you don't necessarily know whether they're telling you the truth, and you got to trust them.
Right. So in your paper, you talk about this idea from the economics literature of the lemon problem. And I think that's really illustrative of sort of some of the sort of market issues that come up because of this information asymmetry. Could you talk a little bit about that and how it works?
Oh, yeah. It's this really neat idea, and it came out of this paper by George Akerlof, who later won a Nobel Prize. I think he shared it with Joseph Stiglitz around the information asymmetry problem. And so think about it this way. Imagine you got or you have a pretty nice Honda Civic, and it's done well by you. It hasn't had any problems, and you have a good Honda Civic. It's not a lemon. You want to turn around and sell it, and you go to the market, and you have an idea about what a quality Honda Civic is worth. But if the people who are going to buy your Honda Civic don't know whether it's a good used car or a lemon, they're going to have to discount how much they're willing to offer you. So if you know your car is good, and the discount doesn't give you fair value for it, you may have to sell if you just have to sell. But most people, if they have the ability not to sell at that price, will choose not to sell just because they're not going to be able to get fair value for what they know it to be worth. So this means that the really good cars are going to exit the market. So if your car is not a lemon, you're not going to unload it at a lemon price. And so if you want to buy a used car, it means that the best cars are probably not going to be available. And if people pull out the really good cars from that market, then you have this another round of discounting that goes on. And so the average quality car that's going to be available goes down. And so as this process plays out again and again, what you end up with is a market where only the worst cars are available, and you're only able to get low prices for them.
Right. So I take it that like in a professional market, then it would be like the most available legal services to unsophisticated consumers are likely to also be the lowest quality legal services, for example.
that is an implication of applying the theory to the market for legal services. I mean, the market for legal services is not like, there's some differences between the market for legal services and the market for used cars. You got to pass the bar exam in order to sell legal services. You don't have to pass the bar exam or the character and fitness requirement to sell used cars.
Right. Right. But so we do have like ways we try to regulate the market to ensure that legal services are high quality. Like, for example, you say, we have law school, like you have to go to law school and graduate from law school in order to be a lawyer, at least in most
states. The MPRE.
Yeah, you got to pass the MPRE, you got to pass the bar exam. And then we have, the bar has committees to, do professional regulation. I mean, we both teach professional responsibility, right? I mean, why isn't that enough?
Well, so part of it is how the bar is. State bars are generally they have this licensing requirement, on getting in, but they aren't always the most reactive afterwards. So when you think about how professional conduct gets policed, usually once you graduate, pass the bar, and get admitted, you may have a CLE obligation. You may have to take these continuing legal education courses, but unless somebody's complaining about you or there's some problem that comes to their attention, they aren't really aggressively supervising. No one from the bar comes around to inspect your practice to make sure that it's up to standards. There's not, there's not a whole lot of oversight once you get past that barrier to entry. And so one thing that we don't do, which I didn't put in the paper, but it'd be something that could work, is you imagine all federal court briefs, state briefs that are filed by lawyers practicing in those courts. Imagine you just ran software to look at them to see if you could flag any that were grammatically so deficient as to raise competence questions. While I was clerking, I had an opportunity to read a lot of briefs of varying quality from different lawyers, and sometimes you'd see briefs come across the wire that really surprised you that a practicing lawyer would file that. I don't know. Have you seen similar stuff?
Yeah. Actually, in particular, I saw it when I was doing pro bono work at Sullivan and Cromwell. And, there was a pro bono client who had fired his public defender because he figured that anyone he wasn't paying wouldn't give him good services, and hired this fly-by-night shyster who basically billed him until he ran out of money and filed one brief and something that was barely recognizable in English and certainly didn't make any real arguments, and then disappeared once the money was gone, and he was back to the public defender, who was quite good, actually. So it was kind of a great example of the
was this person licensed?
I believe he had passed he'd passed the bar and was a member of the bar, but it was very bad. Yeah. But, so of course the client was using as a proxy, like how much he was paying. And I think the assumption was the more that I pay, the better service I'm going to get. Right.
Yeah, no, it's not a good proxy. Not a good proxy.
Yeah.
So so here, oftentimes you'll see that the highest quality services you may be able to get in a particular jurisdiction are available for free. So a public defender, generally public defenders' offices, unless they are overtaxed, overstressed, they need more resources, we should appropriate more funds to them. But on the whole, my sort of sense about public defender offices is that they're generally pretty well run, and they're experienced, and the people who work there care about their clients. And I can't imagine any decent public defender's office where people are practicing together in a group. I can't imagine them tolerating someone in their midst who was essentially just betraying their clients.
Right. But of course, the clients don't know that, because in most cases, this is their first encounter with the legal system. And even if they've had multiple encounters, they may not have a basis to distinguish between competent and incompetent legal services.
Yeah. So the hard thing for so many people that go through the legal system or need legal services is that they're often one-shot players in a repeat player environment. So you have, people that have a legal problem, whether they need, immigration law services, criminal law services, sometimes securities law services, where they have to go through these lawyers who are repeat players in this world, but they themselves are only one-time players. So unless they're going to, they don't tend to get much more sophisticated about how they acquire and pay for use legal services with a one-shot interaction.
Mm-hmm. Mm-hmm.
You wouldn't expect
so
that.
Yeah. So in the paper, you talk about a bunch of kind of existing market mechanisms that lawyers in particular use. It seems to communicate information to somewhat more sophisticated consumers about the quality of services. And like one I thought was really intriguing was to think about like the law firm as actually a proxy or means of communicating information about quality, but also about like policing quality as well.
Oh, absolutely. And this is something I saw in practice. My firm was very insistent about ethics because they viewed the firm's reputation as one of the most critical assets of the firm. And under no circumstances did they want you doing anything that would imperil the firm's reputation. This insight around firms, it really comes from the late great Larry Ribstein, patron saint of unincorporated business associations. But he also wrote about professional responsibility issues and wrote about this issue. And the idea was that if you're practicing in a law firm, then all members of the law firm have an incentive to sort of police each other's conduct, because the last thing you want is to have your organization be known as one that is not so good. If you think about it, just this makes intuitive sense that if you're associated with an organization that has a bad reputation, that's going to hurt your ability to get other work. There was a recent news story about the Theranos debacle, and it's turned out that a lot of the higher level executives or other people who worked there are having a hard time finding work, and that's probably because the reputation of Theranos as this hoax or producing false medical information. So Theranos' negative reputation problems may be coming over and hurting their ability to move in the market. Same. You just imagine if you're a high level executive at Bernie Madoff's operation, you're probably you're probably not going to feature that person on the pitch book when you're looking for new business.
Right.
You should trust us. We have lots of experience. For example, Brian over here used to work for Bernie Madoff, who was a leader in the industry.
The largest Ponzi scheme in American history. That's got to count for something, right?
It's a big win.
Yeah. Well, so what was interesting to me about that observation is that it's like the law firm seems like a response to the legal profession's version of the lemon problem, and yet it solves the problem in a way that allows the attorneys to internalize the bulk of the surplus. And what I thought was really interesting about your paper is that it seems like it's really subtly focused at shifting the benefit from, or solving the problem in a way that allows consumers to internalize more of the surplus.
Oh, absolutely. And so when we think about how to regulate a broad market, I think it has to be in the interest of the consuming public as opposed to the interest of the players who make the money in the market. I wouldn't. When it comes to whether our regulation should tend to favor consumers of legal services or lawyers, my general view is that on balance, if it's not really in clients' interest, maybe we shouldn't make that rule.
Oh, Ben, I fear you are a traitor to our cartel.
This cartel point is it's well taken. A lot of times, professional services organizations, or all it really means to be a cartel is, or cartel-like behavior is that you're acting in a way that promotes the interests of that group over the interest of the public, and that's a real risk here. The hard thing is it's tough sometimes to distinguish between things that are done just for the cartel's benefit or things that are done for the public's benefit. Or there may be wars within the cartel around if particular rules benefit some factions, they may want them to go into play, or you want to put them into place not because they really benefit the public, but because they benefit certain subsets of the cartel.
Right. And has that like structural problem, do you see that playing out in the regulation of lawyers as we currently see it?
So right now, I don't know. It's hard for me to think of particular rules when we think about lawyer regulation that are really designed to focus on the interests of particular subsets of the lawyer population over others. And this may be because so many lawyers practice in solo firm environments or small firm environments. Most lawyers are either solos or work in small firms, and so it's. But at the same time, big firms have an outsized influence on the ABA and rulemaking processes. They have more resources. They're able to do more, attend more conferences, tend to make more money. So when I'm thinking about this, and I'm thinking about how particular groups may benefit over other groups within a self-regulating profession, I tend to think about the structure at the Financial Industry Regulatory Authority, where the way they're set up is partly they have representatives on their board that are supposed to represent the public, that are appointed by the board. Then you also have seats that are elected by large firms, mid-sized firms, small firms. And the reason they're structured that way is around a fear that if they didn't preserve particular seats for small firms, then big firms might use their position within FINRA to push through rules ostensibly in the name of investor protection that would really just drive costs up for their small firm competitors and drive them out of business.
Right. Well, that sounds like a nice transition to talk about the kind of the proposed new or additional way of solving some of those problems that you have, which is in a sense kind of drawn from how we think about regulation and disclosure in the financial industry.
No, absolutely. And so in the securities markets, one of the big problems around public companies is, imagine you're an investor and you're trying to figure out, is this a good company? Is this a bad company? What you need is information to be able to make a decision. Do you want to buy this stock? Do you want to sell it? And if you have to go out and figure all that information out on your own, it's going to be very costly. It's going to reduce your ability to invest. Plus, socially, it's going to be incredibly costly if every investor that wants to do this has to go and do all this legwork on their own too. So instead of making everyone have to go figure out all this information on their own somehow, you make the company that is publicly traded produce information about itself on a regular basis. And the idea is once that information is released, people can then sort of make their decision about whether they want to invest in this particular company or if they want to sell their stock. And so the idea here is you want to reduce that information asymmetry. We do something like this for financial advisors or people who call themselves financial advisors that are registered as stockbrokers right now, and for registered investment advisors. So FINRA has what you call it's the broker check service. So if you have a financial advisor and you haven't done this, this is probably worth the entire podcast. Someone is a financial advisor and they're giving you advice about securities. What you should do is just Google broker check, find the broker check website, plug their name in. If their name does not show up, check it again. Maybe you misspelled it. But if the name really doesn't show up and they're not in that database, then they're not licensed to sell securities, and it's probably a fraud. But the other things, on the other hand, you plug their name in, and there are no red flags, it doesn't necessarily mean that they're never going to cheat you, but your odds are much better. And if you plug their name in and you see that they've been, they've had arbitrations and regulatory complaints and all these other problems, maybe you want to be a little more careful. And the hard thing is most people don't know that this exists. And so, the argument is sort of, you should be able to protect yourself by using these resources. But the problem is, even though this information is in a sense posted somewhere, people don't know they need to go look it up.
Right. Which really emphasizes just how low information most consumers really are.
Oh, absolutely. And when you look at financial information in particular, most, the huge swaths of the American public across all educational levels are functionally financially illiterate. This is people with PhDs, people with JDs, the basic concepts like compound interest, inflation, all of these things. There's people just don't know it, and this doesn't really help them make optimal decisions.
So in your paper, you suggest a sort of version of a disclosure regime for professionals that in some ways resembles the sort of disclosure regime you're talking about in the financial services area. And maybe we can focus on lawyers just because this is a legal podcast. So what would that look like, and how would we solve that kind of like initial information problem of consumers not knowing where to look in the first place?
So thinking about this, imagine you've got an attorney who's been disbarred for stealing client money because he had a crack habit, and later gets readmitted, gets disciplined again. Now, so imagine you've got this guy who's out there. He's got these bad facts, tending to indicate that maybe you want to be careful hiring him. And imagine you're an unsophisticated, ordinary person. You meet the guy. He wears a nice suit. He's a lawyer. He is licensed. And you don't know any of this information. You don't know that there's a way to look it up. So you might hire that person to represent you. And if they go on and they do substandard legal work, you may not even figure it out because you have a hard time evaluating the quality of the legal work. And so the key thing is, if this is something that a customer would or a client would want to know, why do we just post it out there and then blame clients for not finding it instead of switching from posting to pushing? To say, when you start out with the representation, you're just going to have to hand the client these disclosures. You have to make some information available or push it to them. And that way they actually get the information that we think is important that clients, we wouldn't post this stuff if we didn't think it was important for people to know or that they should probably take it into account. But right now, there's nothing like that.
Yeah. So what kind of information do you think should be disclosed and pushed to clients, and why? I mean, is there information that's currently not disclosed that clients ought to have? And, are there things we should be worried about or concerned about in sort of making the decision about what to include?
This is the hard part, and it's very hard to identify, really the right piece of information to include. What you don't want to do is skew client decisions by pushing information to them that has no predictive value or isn't useful. For example, some subsets of law practice, you may attract a lot of customer complaints. Say, imagine you're a criminal defense lawyer, you lose a case, maybe it was, the client who was convicted of murder and the evidence was a blood trail leading directly from the victim to the client. So that's a tough draw. You're gonna have a hard time defending that case. And if the client sues you or complains about you afterward because you lost the case, that doesn't necessarily mean that future clients or that your practice was in any way deficient. If
Mm-hmm.
so, what you want to know for a practice area is, are these sorts of pieces of information predictive? If lawyers that have complaints tend to have worse outcomes for clients, then maybe you want to know that. So setting, just sort of circling in on the optimal pieces of data to disclose. This is a really challenging thing. It's like, what do you push? So some things might be useful, just broadly, you sort of presume that they would be useful. One of them would be whether or not the person has insurance. You would think that insurance companies are sophisticated about pricing risk. And, if you sort of have a preference for somebody with insurance over someone without insurance, if you disclose that information, then when you're looking to hire someone, maybe you prefer to hire someone that's insured.
Mm-hmm.
So win rates could be another example. In areas where you look to see, if you wouldn't expect a lawyer to win all their cases. You can't expect that. But you also wouldn't expect them to lose them all either. And if they're losing, if they do an enormous number of cases and they lose almost all of them, then maybe that tells you something. But even here, defining what is a win and what is a loss is hard, because it may be that you lost on the liability portion, but the damages award against your client was quite small, and so it's really a win. So figuring out whether it's tough to draw really bright lines around what are wins and losses in legal practice. So figuring out exactly what to disclose is challenging. One thing that might be useful would be missed deadlines. If you have someone who has a history of just not filing papers on time without getting an extension.
Right, because there's no reason not to do that.
In theory, no. I mean, you just have to assume that there's. I mean, it's possible that maybe you were going to file this paper on time, but then a meteorite fell out of the sky and knocked you unconscious, and you were unable to do that. But the odds of that happening are pretty low. Like the blameless deadline miss, it's rare.
Yeah. Well, so you used the metaphor of the prospectus, and I gotta say, like, as a former like Wall Street lawyer, when I hear prospectus, I think something that it's going to be really hard to understand. So like, how should we think about that in relation to consumers who are already struggling to understand the nature of the services that they want to purchase and how to evaluate their quality?
A prospectus model, the idea behind a prospectus is that you give, the material information, or a lot of the material information investors would want to know. When you're looking at these kinds of markets, there's also a sort of a danger around length, that if you give people too much information, then they may, so if you think about it, somebody hands you a stack of 40 pages, 50 pages, you may not want to read it. It's just you just look at it, it's like, ugh, that's a lot of stuff there. And if it's dry and not exciting to read, then that model for the prospectus may not work. Or something short, something that is limited to a page or two, maybe would with just some key facts might be useful. One thing that is sort of interesting is, and this is actually, now that I think more about it, this is an example of where the ethics rules may reflect, or the ethics rules for attorneys may reflect the relative power of different practice models. So if you're doing a contingency fee arrangement, you generally have to get that confirmed in writing before you start the representation, so you can actually collect on the contingency fee.
Mm-hmm.
On the other hand, if you are doing an hourly rate, it says that you need to communicate your hourly rate, and it says preferably in writing. This is the ABA model rule. It says preferably in writing, which it's sort of useful guidance that you should write it down, but you don't want to have to. So, I'm thinking about a professional prospectus, or one of the things that would be most salient is, how much are you going to cost? What do you cost on an hourly basis? What is that? what does that compare to for this jurisdiction? So if you're another piece of information that's probably really useful is benchmark information. So if you're saying, hey, I'm $500 an hour and the average lawyer in that jurisdiction is $200 an hour, then maybe just sort of this alerts the consumer that the relative cost of the services they're seeking to pay for, or the lawyer they're looking at is just more expensive. But without that information, I go to the the dealership to get my car fixed, and they tell me it's going to cost this amount to replace a transmission valve. The process of collecting that information about what the average cost of something like this is really burdensome.
Right. And
so, it may not be worth my time.
Yeah. And so making the information available to consumers in a more convenient way where they can sort of process that without having to do all the legwork could increase, at least on the margins, the ability of consumers to sort of seek out higher quality representation.
That's the key to the idea. So the idea is sort of we have these systems for policing professional competence, with licensing and occupational licensing and the oversight of state regulatory bodies that sort of watch us. But market forces don't play as much of a role in policing quality as they probably could, in part because for market forces to be effective, people need to actually be able to discriminate on the basis of quality. And that's a challenge.
Yeah. So I wonder, what response or responses would you expect from professional organizations and their members? And I mean, is there a concern that perhaps the reason market forces aren't working is because professions like it that way?
So on that front, it's going to be difficult probably to raise. Imagine you've got a meeting of the state bar, and you're going to put in place a new system or a new rule that requires you to hand unflattering information about yourself to your clients at the beginning of the relationship. I can't imagine that you're going to have a large constituency to support the idea. I don't think it's going to be particularly popular.
Yeah. I mean, but don't we as a profession have a self-imposed duty to provide that kind of information to potential clients so they can adequately be prepared to evaluate the quality of the services we're likely to provide, for example?
Yeah. There's in the paper I went into some of the research on the medical side, and I think there are some cases now where let's say a surgeon is really excited to try a new procedure and they've never done this procedure before, but they're excited to try it and they want to take their scalpel out and they want to try it on you. So if you're going to be their guinea pig or their first run through of this kind of thing, you may not be able to say that there was truly informed consent to the procedure unless the person knew that they were doing this for the first time. So,
yeah, that makes a lot of sense. So Ben, in closing, I wonder if you could reflect a little more on the potential for implementation of this idea, either in kind of the robust form that you outline in the paper, or maybe in more baby steps forms. Like, how might this work? How might we accomplish this better? And is there the possibility of even a kind of a third party model of doing this? I mean, is there a way that it could be aggregated and disseminated even without the kind of profession's consent or involvement?
Oh yeah. So lawyers practicing before administrative agencies, sometimes they have to register. They have a number that's associated with them. And if that agency decided to release statistics about the lawyers practicing in front of it, that would just put the information out in the public domain and make it easy for people to make decisions using that information. So uh, one interesting thing about this is that a lot of times the information is already public record because it's information that's in a public court process. And so if you just release that information in a different format, like if courts decided to do it or administrative courts decided to do it, it could really reveal a lot of information about relative practice rates or relative what happens with different attorneys in different places. One area, think about. There was a New York Times article a little while back about a law firm in New York where the firm had brought somewhere between, I think it was roughly 1,000 asylum claims over a 10-year period, and they won 2 of them.
Oh, Jesus.
And so, in that, so here I want to be very clear that most immigration lawyers are great. If you are going to go to an immigration court or you're having anything like that, your outcomes overall are much better if you have a lawyer. You want a lawyer, but lawyers are not commodities in that there's asymmetric skill, and so if you were looking at you have an asylum claim or you want asylum and you got to go in, you want to pick a representative to help you through that process who is going to be able sort of position you as best you could. And so you might not want to pick the law firm that has a record of 998 losses to 2 wins. You don't want to shop around. And so as I say this, that example is it's kind of extreme. That most rates are not quite like that. But the other things is it's also, the statistics are also very hard to apply here because you have if you're thinking about the immigration court system, it's basically roulette when you go in, depending on which judge you get. Win rates vary dramatically depending on which judge you have, so you'd have to control for that. And the hard thing is it's just really very difficult to do.
Yeah, no, very true. And, it just does seem like it would be there's just a lot of potential there to help people achieve better outcomes in circumstances where, there's no reason for them to be in the dark like that.
No. And there's not so the challenge to the idea, and this is, I think, a real challenge, is that if you start revealing information about lawyer win rates in particular kinds of cases, lawyers are smart. We are strategic creatures, and we may change what we do in response to these sorts of disclosures. And so if you want to make money and you want a good win rate to make sure you make money, you may only take easy cases, or you may transfer any case that gets difficult to somebody else. And that's not necessarily going to help people. It's not going to, that's not really good. But the ultimate question that the article is asking is sort of, we got a world right now where people, the least sophisticated people are at the biggest disadvantage, and they have a very hard time identifying who a good practitioner is. And so do we want a world with problems that come from too much information and too much strategic behavior, or do we want a world where people have too little information and can't act to protect themselves?
Yeah, it's like, don't let the best be the enemy of the good, as it were.
Yeah, there's not this idea. It's an idea to maybe try to improve how the market functions here, but a market model may not be the best model for providing legal services in a lot of contexts, because maybe it's just evil to say that only people who, I mean, we recognize this in criminal defense, like only people who can afford it can have a lawyer. We don't do that for people who face criminal charges. But it's, if we're not willing to provide these kinds of services publicly, then the market is all we have.
Mm-hmm. Yeah, no, it's true. Well, Ben, thanks so much. It's been great talking about the paper, and I hope we do see more information about the quality of legal services, because if anything, teaching professional responsibility is a daily reminder of the failings of the profession.
It's the profession, I think, is only going to benefit, I think, from focusing on these issues, talking about them, and trying to tilt it more in the direction of protecting the public.
Attorney Ed Denton, what's your IQ?
135.
And your EQ?
EQ?
Your economics quotient.
Economics? I never had time to get into it.
Lots of people, even people you'd ordinarily consider smart, have EQs that could stand improvement. How about yours? The place to start is your local library. It's full of information on the American economic system and your part in it. The American economic system. We should all learn more about it. A public service message of the Advertising Council and U.S. Department of Commerce, presented by this station.